I thought we'd talk a little bit today about domestic abuse and coercive control. We're both here from Ridley and Hall Solicitors, and it's becoming much more of a relevant topic at the moment, and something of personal interest to me, and always has been in my career. Um, so, do you want to say a little bit about it too, Zuza?
Yeah, I think whenever we talk about domestic abuse in private family proceedings, the starting point is the Practice Direction 12J. For us as practitioners, this is something that sets out the rules about domestic abuse and how this is managed, and then allegations of domestic abuse are managed in private family proceedings. So that Practice Direction 12J forms a part of the family procedure rules. Those are rules of conduct and procedure that we as practitioners observe. And as a starting point, it defines the domestic abuse. Now, the definition is very wide, and interestingly, it includes an incident or patterns of incidents of coercive, threatening, or harassing behavior. And it becomes a domestic issue where it takes place between people who are over the age of, well, 16 or over, and who are in a family relationship or are intimate or have been intimate with each other, and that's regardless of their gender or sexuality. So the definition itself is very wide, and it can include, although it's not limited to, the psychological, emotional, physical, sexual abuse, but also a coercive and controlling behavior and the financial abuse, something that we wanted to talk about today in particular.
Yes, and interestingly, controlling behaviour also has its own definition, which includes exploiting another individual and actually their resources. So that can mean depriving an individual of money or resources, or preventing an individual from escaping a relationship. Um, and that can be really significant in family law. It also means it impacts their ability to become independent from that relationship. So, yeah, this is where the law is quite interesting and developing. Um, Coercive behaviour also includes threats, humiliation, intimidation, and can include attempts to harm, punish, or frighten another.
Yeah, and just to talk a little bit more about procedure, actually, wherever there are any allegations made in proceedings, family law, private proceedings, as we as practitioners know, wherever any such allegations are made, the courts have actually come up with certain rules that then can be applied to protect the vulnerable parties, and that those rules include how proceedings and court hearings are conducted, making sure that people are protected. And they can be in terms of attending the court for vulnerable parties. They may be granted with something that we call special measures, in that they are provided with separate entrances to the court buildings, separate waiting rooms, and screens during the court hearings. This is all to protect them and make sure that they are separated from their alleged perpetrator. And then, in addition to all of that, there is a general prohibition of cross examination of victims of domestic abuse. That means that the court does not allow the alleged perpetrators to pose any specific questions to their victims in terms of any final hearings where the parties are required to give evidence. Instead, somebody called a qualified legal representative is appointed, and that person is a specialist solicitor or barrister who will conduct cross-examination on behalf of that alleged perpetrator, again, to make sure that the victims are protected. But as we know, sadly, from practice, there are still some ongoing issues about the qualified legal representatives, and those particularly involve availability. Sadly, it is difficult to find an available qualified legal representative, and often it causes a further delay in proceedings, having to look for one and appoint one.
Yeah, I think that's right. There's a reluctance for practitioners to become involved in the scheme. I don't think it's really adequately funded. I think that's one of the issues. So that is a bit of a problematic area. Just to kind of hone in a little bit further, because this chat in particular, I wanted to mention finances and how this has a real impact for family people trying to separate from a relationship. And I suppose honing in on that is the economic abuse definition. That's defined by the Domestic Abuse Act of 2021. And again, it's quite widely defined. It includes adverse behaviour designed to affect an individual's ability to acquire, use money or property, or to try to prevent somebody from buying goods or services. So it's quite controlling economic financial behaviour there.
Yeah, and I think the whole reason why we wanted to talk about it today is the very alarming statistics that have recently been released by Women's Aid, who are England and Wales charity working with victims of domestic abuse. Those statistics reveal that nearly a third of those people who have taken part in the Women's Aid survey have experienced control in access to money in their relationship. And a quarter of those surveyed actually indicated that their partner did not let them have money for essentials during the relationship. On top of that, a third of surveyed people actually experience having to leave their homes in order to leave the abusive relationship and separate from their partner. So we can see here this is a very live issue. The control, economic financial control in relationships is very much present and experienced by a large number of people. 43% of those who were surveyed by Women's Aid have actually admitted that as a result of leaving the relationship, they were left in debt. And a staggering 56%, that's more than half of those surveys, actually indicated that after leaving their abuser, due to the abuse suffered during the relationship, including economic abuse, their ability to work was affected and their future earning capacity was minimal as a result. So clearly, this is a very live issue and something that we do need to be talking about.
Yes, it's certainly a developing area of law. Having said that, the idea of conduct having an impact in the resolution of financial remedy issues has been there as far back as when they introduced the Matrimonial Causes Act 1973. It's in there in section 25. But historically, conduct had to be something obvious and gross, or something that really out there, such as murder, rape, something really quite alarming. And case law does suggest it needs conduct only relevant if it's inequitable to disregard. So this is where there's the developing area of law. It's what's inequitable to disregard, what's alarming to ignore, and there's a societal shift, and there has to, in my practicing years over the last 25 years, things have changed, and what's acceptable in terms of behaviour and conduct is vastly different. There was case law in 2020, and this perhaps is when we started to see a shift in change in financial cases. And in that particular case in 2020, the court decided that there were 4 different categories that were helpful to consider. One of the categories is where conduct is gross and obvious personal misconduct, which can be economic. The second type of case is where there's deliberate, reckless, wanton dissipation of assets. So that might be vindictive and irrational transactions, deliberately motivated to deprive the other individual from the benefit of that asset. The third type is litigation misconduct. So where an individual's not complying with financial disclosure, not complying with the court's directions to share information or answer questions about money or property that where we can't seem to trace where items are. And the fourth type of category is non-disclosure. So that perhaps that's where somebody's just not willing to share any information at all, or hide something. The courts have come to recognise, having said all that, that it can be difficult in some cases and sometimes impossible to add up and quantify the loss to an individual of their conduct, whichever type it is. How do we compensate that individual? How do we give that an individual who suffered that type of conduct a fair outcome? One of the solution that the court has, and this has perhaps been becoming more commonly used, is that the court can impose cost orders to penalise an abuser, and that is going to happen more so in relation to litigation misconduct or non-disclosure, but the courts are also opening up to look at other remedies, wider remedies too.
And one of those remedies, as again we have observed in practice, is actually the court exercising their powers of ad back wherever there are proven allegations of financial misconduct and economic abuse, and it can be proven that a perpetrator of that type of abuse has actually dissipated the assets, and those assets have disappeared from the matrimonial pot as a result of that economic abuse. In those circumstances, the courts do have powers to actually add back the assets that were taken as a result of the economic abuse and add those to the settlement that the victim will be receiving at the end of financial remedy proceedings. So this is all very helpful. However, the other side of that is that sadly the courts are unable to recreate money of assets. So if the abuser was successful in dissipating assets and making those be taken out irretrievably from the matrimonial pot, the courts will not be able to actually exercise the ad back powers, because the court can only redistribute what is in the matrimonial pot at the time of the final financial order being made. So we can see that the courts do try being as fair as possible, and where that financial and economic abuse is proven, there are powers of the court available to actually act in a way that will compensate the victims. And having said that, it is also quite helpful that the courts have started to consider the cumulative impact of that economic abuse. Sometimes it is very difficult to pinpoint one specific act that resulted in economic abuse, and that abuse can be very subtle, sneaky, and enduring, and can encompass a number of behaviors that accumulated amount to the economic and financial abuse. And the courts are more and more alive to that fact, and they do recognize that in proceedings.
Yes, and I think there was a very interesting case most recently in 2023. That case involved a dominant spouse exploiting a very vulnerable character in that relationship. I think the character was financially vulnerable because they were blind, they were dependent on the other individual managing the finances, but their expectation, I guess, would have been to do that in a fair way, but that unfortunately that didn't happen. There was a significant financial abuse in that case over a very long period of time. And in that case, the court recognised the conduct in that wider sense that we've spoken about earlier. They decided an outcome in that case that was weighted in favour of the abused party to try to put the situation right as best they could, even though they couldn't actually quantify it as such. They just had a strong sense of justice to remedy the situation.
Yeah, and I think the more cases we see in practice, the more we understand that on a practical level, if a victim wants to allege financial economical abuse and plead that in their case, this should be done at the very outset of the case as early as it is possible. That's because the courts have very wide case management powers, and they can make specific directions which will ensure that the matter of that alleged financial economic abuse is actually at the forefront of the proceedings. So the earlier we set out all the facts of the case to the court and bring the judge's attention to the issue of a possible financial economic abuse taking place, the better for the management of the case in general, and then hopefully a positive outcome for the victim where that abuse can be proved.
Yes, the courts want to know, as a matter of fact, before moving on to the resolution options, what has occurred during the relationship, and then they can move on to the second point, really, is how to achieve fairness in those difficult situations. And I guess it comes back to, or we mention again the qualified legal representative for unrepresented abusers. It's they got the best of intentions, this process, but it's a difficult practical issue at the moment because the scheme is struggling to recruit. There's just a shortage of availability, and it is creating delays. That sounds a little bit negative. It's an interesting and emerging area of law, and I think it will take time for us to see improvements. But hopefully we're beginning that journey now, and the more cases come through the system, the more equipped the system will become to manage and listen to people that are in that horrible situation of having suffered abuse in their relationships.
Yeah, I agree. I think we see a real shift in the court's approach now, and I think we just need to watch this space. But I think we are witnessing some real improvement of treatment of the victims of domestic abuse within proceedings, and also clearly the fact that courts start picking up on a very subtle economic abuse more and more, and that's a very positive breath of fresh air for those who have suffered that type of abuse during the relationship. Um, it was a very informative talk for me, so thank you, Karen. I hope we have helped those who wondered about the matter of financial abuse in the relationship and wanted to explore this subject in more detail. At Ridley and Hall, we are specialists in that type of proceedings, and we can definitely help victims get their justice as much as we can. So if you do have any questions, please do not hesitate to contact us.
Yes, certainly. Please do. Thank you.
Thank you.
Thanks, Zuza.
Thank you.